This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with Michael Greve the challenges to constitutional government. Michael Greve is George Mason Professor of Law at the George Mason School of Law. Before that, he had a career at the American Enterprise Institute as the John G. Searle Scholar, and also was the co-founder and director for a decade of the Center for Individual Rights. Michael Greve, as many of you know, was a contributor to Law and Liberty, one of our first writers, and had a wide audience on questions of federalism and administrative law, owing to his 2012 publication by Harvard University Press of the Upside Down Constitution. He's the author and editor of dozens of books and numerous articles, op-eds, and major publications. Michael Greve, welcome to the program.
Thanks for having me, Richard. Glad to be here.
So think about the arc of your career, Michael. You're, on one hand, that dreaded thing, a Washington, D.C. veteran. You've been inside the Beltway, by my count, for nearly 2 decades. You worked for AEI, one of the biggest think tanks, and also you co-founder of, I think, the first conservative, classical liberal public interest law firm, the Center for Individual Rights. You guys...
Yeah, one of the two. It was, the Institute for Justice and CIR were founded the same year, within months of ech other.
Okay.
So great minds think alike.
And won some significant cases, Hopwood versus the University of Texas being one of them. And then a PhD at Cornell under Theodore Lowy. So, but before all of this, you immigrated to America from West Germany in 1981. I think my opening question to you is, thinking about your experience in America and Washington, D.C., what's gotten better and what's gotten worse with regards to constitutional law in America?
I doubt that my perceptions of this differ very much from the natives. On the one hand, my arrival here coincided with the rise of originalism, constitutional scholarship. That was then a crackpot notion propagated by Ed Meese and a few of his friends at the Justice Department, and by now it's become conventional wisdom. And while, as many of your readers know, and as you know, I have some quarrels with,
to put it mildly,
the question of
yes,
whether that's quite enough, on the whole, that has been a totally beneficial development. And on the other hand, in real life, things have gone, by most accounts, from not so good to really, really bad. Right, because what you've seen over those decades is the ineluctable ascent of executive dominance and executive government, and that's not to the good.
Yeah, thinking one of the areas you've published and written in and thought a lot about is administrative law, which has emerged largely, I think, because of certain moves President Obama made, has one of the most significant fields of study right now in legal academia, and very contentious as well, and also very a topic in political conversation, and also reaching now to involving discussions about Congress and what's it doing, or rather what's it not doing. Do you see the issues around administrative law, as one of the biggest problems facing constitutional government right now?
Yes, it's a huge, huge thing. So just to describe the scholarly and literature development, which itself is kind of interesting, there was a big upheaval in administrative law in the 1970s, and I caught the tail end of that when I studied this stuff at Cornell. The big move then was to make administrative law more open, turn it more into an interest group circus. And, of course, the big debates over Chevron, which was decided in 1984. And then, for a long time, I left that stuff alone.
Talk about that just for a minute. You say interest group circus. And I know that's important in some of your later analysis. What do you mean by that?
What I mean by it was that the courts deliberately moved from sort of the old APA model, which basically didn't give outsiders an awful lot of rights, to a model that said we have to throw the administrative agencies themselves open to interest groups. And the way to do that was to give them increased access to courts. Right? So that meant much, much lower standing barriers, much more revised notions of administrative finality so that you can challenge these decisions earlier on, and much more focus in the administrative process on rulemaking as opposed to adjudication.
So I suppose...
Yeah,
go ahead. I suppose, though, for a lot of our listeners, this, they hear a new controversial executive order comes down from the White House, and immediately someone in the press says, but it will be challenged and suspended, pending suit. Is this sort of what you're talking about? It's very easy to challenge. Yeah.
Yeah, that's a very big piece of it, and you never know. I mean, in these immigration disputes over the so-called Muslim ban, which isn't one, right?
Yeah.
What's it to the states? Whose behalf are they suing on? And it turns out people who have no right to be here in the first place. That sort of thing is very, very telling and illustrative of what I have in mind. And so if you look at if you look at Chevron itself, the case is called Chevron versus Natural Resources Defense Council.
Yeah, okay.
It's as if the agency that's in the middle of this is just sort of a forum for stakeholders to fight it out. And that's very different from an administrative law model that says, no, wait a minute, administrative law is between the government and some regulated party.
Some party that is under a binding judgment, and all of these interest groups can intervene. So, it's also interesting, we think about administrative law. What are the two poles of the debate now, as you see it, that are sort of contesting for ground? And then, maybe, because I know you've written some about this, fruitful ways to sort of mediate the tension.
Yeah, that may be beyond my poor powers. I strongly suspect it is. But on one side, so to continue the story that I mentioned earlier,
sure, please do.
I left that stuff alone for a long, long time because after Chevron, everybody purported to know what the rules were. And of late, that has broken up. So on one side, you have people prominently, Adrian Romero at Harvard, who's written very, very good books about this. There's no law here at all in any meaningful sense. It's just a collection of black and gray holes, and the law disappears, and everything gives way to executive discretion, and the controls on that discretion have to be political. They can't be legal. That's one side. And on the other side, you have people who say there's something to that, except that's altogether a bad thing. And we have to think about ways of reconstitutionalizing this universe in a very fundamental sense. So Philip Hamburger is the ringleader in that particular arena, Gary Lawson in a somewhat different way. Those are the two poles as I see them. And more, the conventional administrative law scholarship in the middle has to confront those challenges from both sides, and that's an ongoing process, both in sort of big, noteworthy cases where this has come up and where this has hit the Supreme Court, and, of course, in the scholarship.
You mentioned the Administrative Procedure Act early in your answer. How does that factor in to, just the workings of administrative courts in general? Is it something we've largely departed from? And as Adrian Romero sort of articulates, and you've just said, there is no real law here. There's just sort of practices or conventions that courts try to enforce.
There are many ways, several ways to look at it. So the APA itself, if you look at the bare bones text, that's a statute in exile. It's been overlaid with sedimentary layers of administrative law reforms, one after another, administrative common law that governs this universe. At the same time, the foundations of the APA have remained intact. And one of the central features, and maybe we can talk a little bit more about it as time goes on here, is it adjusts judicial review to the forms of administrative action. So there's formal and informal adjudication, and there's formal and informal rulemaking. And while the forms of these actions have changed over time, what has remained true is that the scope of judicial review, what judges do about it, is tailored to the forms of administrative action. And in so doing, the APA and modern-day administrative common law abstracts completely from what exactly is at stake here. So for the formal purposes of the APA, it doesn't matter whether they try to take your land or try to give you food stamps. It's adjudication one way or the other. And the judges are completely oblivious to questions of private right. That turns out to be one of the most confused areas of all of American law. But that's the APA that was aggravated, it seems to me, by this deliberative model, interest group model of administrative policy making that we inherited from the 1970s. And that is where we are, and that is what a lot of people now are rebelling against.
So this is, thinking about something Adrian Romero has said, and maybe we can just really take up some of his arguments here. But, one of the things he said is we basically now have an unwritten executive-centered constitution. And this is where all of the action is. As a result, if that's true, then it seems logical that we want to sort of reintroduce this sort of participatory democratic process as best we can. And this executive context. And so is this, what you're saying is this is a problem, and I suppose he would say this is inevitable, that we would have this sort of back and forth interest group stuff going on.
Yeah, at that point, I think most people would say, especially if the legal controls are so unworkable and elusive, at least make sure, or let's make sure that there are political controls. And those can come from various sources. They can come from the media, from the need of the president to run for re-election, or, as the case may be, they can come from making sure that interest groups are fairly represented in this process so that it's transparent and accountable and open in that sense. And serious scholars have argued that in that regard of accountability, openness, democratic legitimation, the administrative process may actually be better than Congress. I have my doubts about that argument, but that's where we are, and that is a potent streak in contemporary scholarship. So, I'm not sure Adrian Romero would share that sense, but that is what it is.
No, and he seems to, as you noted, you reviewed his latest book on the administrative state for us. You noted in particular that he recognizes, and others have said this about the book, Richard Epstein also, that there's no limitations on executive power. Principle that he seems to recognize. He seems to think that this is a necessity, and living in a postmodern democracy, that we should have an executive administrative state that can do whatever is demanded of it.
No legal, constitutional, formal constraint.
But things like, he would say public opinion. He would say public opinion in one book, yeah.
Right, so and mind you, and you can make an argument that there are, in fact, an awful lot of blocks and impediments, and there's an awful lot of friction in the system to the point where maybe you don't want to be concerned about executive tyranny. Lots of people have made that kind of argument. Jack Goldsmith, in a very important book about how the war against terror played out under the Bush administration, which found itself confronted with an awful lot of roadblocks despite the fact that they were operating under completely open-ended statutes. That's one example. And not so long ago, in November 2016, people thought and said out that here comes the Trump tyranny. Well, it hasn't played out that way for an awful lot of reasons. But I think one of the reasons is the immediate blowback that you get just politically and not just from law and courts.
Yeah, it's interesting. So I want to sort of bring out part of your analysis here that I think is interesting and is, in many respects, represents a challenge to sort of the mainstream thinking of conservatives and libertarians regarding the administrative state. So we think about certain absolutist responses, I think, from many in legal conservatism or libertarianism to the administrative state. You argue they don't cut mustard. I think, with the reality of things, with the reality of this beast of the administrative state. Talk about why.
Several reasons. So there is a streak in conservative thought, which I'll now characterize, okay? And I have a lot of sympathy for the way of thinking, but ultimately I think it's insufficient. And it goes like this. The progressives, with their idiotic ideas about expert government, did this to us 100 years ago, and so therefore it's all ideology, and once we put up a fight and repudiate that way of thinking about government, we'll all be better off for it, and so problem solved. And I don't think that is historically right, and I don't think it's right as a matter of thinking about pragmatic or practical reforms that actually have a chance. And there's a similar streak, somewhat different, in constitutional thought, which says that the entire Constitution went by the boards in 1937, and until and unless we sort of restore limited federal powers and all the rest of it, and a non-delegation doctrine with teeth and so on and so forth, there's no salvation. We're not going to do that. And by the same token, the reforms that were enacted 100 years ago under progressive auspices, I'm no great fan, don't get me wrong, I'm no great fan of the agency model or anything else. But you can see the real-world pressures behind it. So all of a sudden, pharmaceutical drugs show up and no customer has a chance to examine the quality of the product or its safety in advance. Somebody's got to license this stuff in some way, shape, or form. The Congress cannot do this. The courts cannot do it, and it would be probably unconstitutional if they did. So it's got to be an executive agency of some description. And there are lots and lots of those kinds of examples where the formal distinctions that you may want to draw and that you may want to stamp your foot on and that have a great deal of initial plausibility on a blackboard, where all of those distinctions break down and you have to think about operating in a second-best world.
So, and also, I mean, you focused on, in particular, I know, criticizing Chevron deference and our deference regarding this sort of this is the holy grail of reforming the administrative state. Do you think, and sort of when we see this tremendous focus on, disinterring these interring these doctrines, do you think that comes out of sort of this originalist, formalist emergence in legal conservatism as the way we should do business overall, and bleeds into administrative law analysis?
I think that's right. I mean, there is... Chevron critics are frequently very...
And I suppose we should just state the doctrine for those playing along at home, what that is exactly.
Okay.
Yeah.
So what the doctrine says is, formally, is that when the language of the statute is clear, then we, the courts, will follow it, and the agency must, of course, follow it. When the language is ambiguous, the agency can, within bounds, exercise its discretion and decide what it means, and we, the courts, will give deference to that interpretation.
Okay.
The entire doctrine, as formulated, is focused on a particular form of agency action, which is called informal rulemaking. It also applies in other areas, but that's its core, and everybody is preoccupied with that. It seems to me, so long as you are talking about the judicial review of what an agency did in a rulemaking proceeding, you're forced into some form of deference. And the reason is that the initial decision is a policy decision. So in Chevron itself, what was at stake was the interpretation of the word source under the Clean Air Act. Does that mean every valve and boiler? Or does it mean the entire facility, a power plant or refinery or something of the sort? Everyone understands the economics. It's a judgment call. It's a policy call which way you want to go. There's very, very little law here, and certainly nothing in the statute itself. And so you can formulate the doctrine that comes out of that recognition any which way you want. At the end of the day, the courts will give deference to the agency under some moniker in that context, for the excellent reason that the question is always, what do the judges know that the agency doesn't? Right? And so you want somebody to take a look at it and maybe bring a somewhat more generalist perspective to bear on it, so that as to make sure that the agency doesn't go down the garden path, and because it has tunnel vision, you may want to make sure that they acted in a regular fashion, to which the answer is usually yes. But beyond that, no one seriously thinks it would be an improvement if the court then substituted its view for what the agency considered in the first place, and you really have to wonder about the costs of making the same decision twice. And I think you don't get out of that conundrum and the sort of push or pull towards judges saying, never mind, until and unless you get out of that mindset, focus a little more on adjudication as distinct from rulemaking, where you have a little more or a lot more work usually to work with, where you're confronted not with interest group demands and expert witnesses on one side or the other, but where you have a real live case between the government and somebody from whom the government wants. And once you focus on that, you naturally focus a little more on substance and on questions of private right, and maybe there's a chance to get that part of it right. But so long as you operate in this universe of what exactly should the standard of deference be, you've conceded the ball game.
You conceded the ball game. So I take it a world without Chevron deference in practicality would result in an executive administrative state not doing anything, or those appointees not even being able to make any rules. Or would it just be sort of dishonesty all around, because there has to be action somewhere in some way.
Yes, somebody has to. Again, I'm open to reformulating the doctrine. I'm certainly open to saying, now look, the real fight under Chevron, okay, is not over the broad parameters of the doctrine, really. It's about totally different questions. And the central question to my mind is, how closely do justices read the statute to begin with?
Okay.
So Justice Scalia, the late Justice Scalia, who was a big fan of Chevron, one of the fiercest defenders until very late in his life and his career, always insisted on reading statutes very closely, and said it's ambiguous only if, after I've done all the work that I can do, I still find it ambiguous and unclear. It's only then that I give them the discretion to go off on their own particular reservation. Whereas in the lower courts and in the hands of other justices, the doctrine is, let me look at the statute. If I have a question about it, I'll call it ambiguous, and therefore it's free sailing for the agency. That's a matter of how you deploy statutory canons, how you think about statutory interpretation. It's not a question about Chevron per se. And so my worry about the preoccupation with Chevron is I don't want to play in that playpen because the other side always wins. Because once you recognize that these are policy decisions at the end of the day, the pull towards deference is irresistible. I think Adrian Romero, that's one of Adrian Romero's central contentions. And on that central point, he is absolutely right. There's no answer to it.
Thinking here, I mean, why does Scalia turn against or soften his support for Chevron deference later in his career?
I think, in part, in large measure, it was the experience. He never meant it as free sailing for the executive branch and for executive agencies, but that's what became of it, and I think that was a big part of his concern. He had other concerns that, in large measure, reflect the scholarship people did on deference doctrines. So on a related deference doctrine, which I won't bore everyone with, John Manning, one of his former clerks, wrote a very important article.
Now Dean of Harvard Law School, yeah.
Yes, now the Dean of Harvard Law School. Look, that deference doctrine has no basis. That persuaded Justice Scalia. On other questions, whether Chevron is even consistent by its with the language of the APA, there was a emerging scholarship that said or suggested that it might not be, and that too probably influenced or impressed Justice Scalia. So there was a mix of motives and considerations, including the consideration that the stuff had obviously gotten out of hand.
Okay. Yeah. So, I mean, and I think you saying obviously the stuff got out of hand. I mean, I think what we haven't been discussing in the podcast, maybe we should have mentioned, is sort of the elephant in the room, which is Congress. Passing these statutes and passing them in such a way as to be deliberately open-ended, and in large measure, many would say, to take themselves off the hook for accountability for the legislation they pass.
I think that's a large measure of it. What the modern-day approach to administrative law, as it was formulated in the 1980s, had in common with the New Deal model of administrative law and the administrative state was the will of the Congress must prevail. That was always the baseline, okay? And the recognition set in at some point, what if these characters have no will? Or if all the institutional mechanisms to exercise that will have broken down? And if we're operating not with a useful fiction, all law is full of fictions, and the will of Congress is another one, what if that is no longer useful but produces all sorts of pathologies? What should the doctrine look like then? And that's what a lot of people are struggling with, and I don't think anybody has a very clear answer at this point.
So how would you, I mean, if we think, so we know broadly how many conservative libertarian legal scholars want to reform the administrative state. And your response, and I think you've sort of hinted at it, is one thing we know we could get right is the ways in which private parties are affected by administrative judgments, administrative legal judgments, policy judgments. We could make that more clear-cut and people know what to expect and also know their remedies if they think they're harmed.
Yes. With this caveat that you would probably, I mean, once you say that, it sounds easy, right? And you could easily say or propose, and this is floating around in the law reviews now, look, ramp up the standard of review for adjudication. Cases where individual parties are adversely affected. Coercive government action that interferes with something that we recognize as a common law-ish right, even if it's not exactly the common law. Once you say that, you really have to rethink big pieces of the institutional architecture, it seems to me, and that thought has barely begun. Right, so just give you one example of this. Under standard administrative law principles that nobody doubts, the agency is free to choose to proceed by adjudication or rulemaking. If you ramp up the standard for adjudication, they'll never do it. They'll just write rules, and then you're toast. Right, so long as the deferential canons still prevail, and it's a little harder to write rules and all the rest of it, and maybe it'll give them an incentive to write rules. That's all fine, but still you confront the basic question. And a larger part of it is that the adjudication in the first instance would still be in the agency, and then it's a little late in the day after that to say, oh, you can always go to court, because that entails, first of all, a lot of time and difficulty, all sorts of doctrines that may stand in, and in any event, it's quite costly. So you want to think about a system in which you could perhaps separate adjudication, not by Article 3 courts, but by real courts, from the agency itself and from the agency's mission. There was actually a proposal made in the 1930s when people first started thinking about this. Some proposed, let's have a big administrative court. Not Article 3 judges, they could be appointed for 15 years or something, but non-specialized and not inside the agency.
Okay.
For all sorts of reasons, that was abandoned because nobody liked it, for varying reasons on the left and on the right. But I think the time may have come to roll that out in full regalia, or at least to think seriously about it, because what you want is more systematic legal control over administration, a disconnect between adjudication on the one hand and policy making and development on the other.
So would this be something like separation of powers within the executive? Within the administration? Yeah, okay.
Excuse me. You can call it that, and you can look at it that way. But what I would want to make clear is that whatever this administrative court or administrative machinery is called at the end of the day, you want to make it clear that they're separate from any individual agency.
Okay. Now, switching gears here, Mike, you've also written, and we don't have to get into the federalism arguments of the upside-down Constitution. We've discussed those at length and other ways at Law and Liberty, but the upside-down Constitution also has this idea of a John Marshall classical liberal understanding, philosophy of the Constitution, as opposed to clause-bound originalism and thinking about our constitutional order and dealing with the challenges that it faces. What does the Marshall philosophy that you've outlined give us that's of more value than originalism?
Well, let me first say, I mean, none of what I'm going to say now is against originalism, against starting with a text. I, for one, don't comprehend where else you would start. The point is, that's not quite enough to make a constitution go, because the Constitution is a law of a kind. It's meta law, not ordinary law. It's very different from statutes. You can't read it like a statute. That is one of the key insights that you get from John Marshall if you read 2 or 3 opinions, starting with McCulloch versus Maryland. The second point you get from it is that all the work in constitutional law at the end of the day is in doctrine and not in the text per se, because again and again, in cases that actually matter, the text runs out on you. Once in a blue moon, you get a case like the gun rights cases where the Supreme Court encounters the raw text, and in those kinds of situations, originalism, textualism, clause-bound textualism can be quite persuasive and frequently is, but that's not the ordinary course of events, and that's not the normal case, so you have to get the doctrines right, it seems to me. That's the second point. And the third point is, John Marshall had this, he came close to saying it on many occasions. The founders were too wise to give us an imperfect constitution. And so your job as a justice of the United States Supreme Court is to make that document work as well as it will under changing circumstances. And the doctrines may change over time, even as the Constitution itself and the text itself remains constant and inviolable. And you try that argument out on certain kinds of originalists, they will rebel. And I think that's the wrong discussion or the wrong position if you talk yourself into an excessively narrow version of what's permitted and what's not by way of doctrine under an originalist conception. You very quickly run out, and that's a form of, I think, unilateral disarmament at the end of the day.
When you say, are you saying that's sort of a progressive understanding of what John Marshall's about, and the sense of the Constitution doesn't change, but doctrines will change, and if but that's not. Are you saying that's not an accurate understanding of what the John Marshall constitutional philosophy is? I guess I maybe flesh that out more.
Look, there are lots. You can think of lots and lots of doctrines that have changed over time, and where they have developed. That's the very nature of doctrines. But you still have to be able to go back to the original constitutional precepts with which you started. And so here's an example. What exactly is it that permitted the United States to emerge as an industrial powerhouse from this rinky-dink country at the edge of the world? And the answer is in two legal doctrines, both creations of the Marshall Court. One is the federal common law of Swift versus Tyson, and so that you decide interstate disputes of a certain kind, of a commercial kind, under federal common law, that not state common law, federal common law that's developed by federal and state judges at the same time. That's one doctrine. The other doctrine is called the Dormant Commerce Clause, which basically says that states cannot discriminate against out-of-state conduct. Neither of these doctrines is in the Constitution in any robust sense. Lots of people think both are unconstitutional and ought to be abolished and abandoned. Swift versus Tyson has been abandoned, and the Dormant Commerce Clause doctrine should bite the dust. But there would be no America as we know it without those doctrines, and I think both of them are quite faithful to the spirit and the letter of the Constitution, and I would defend both of them quite vehemently. And if that is anathema, well.
So that would be...
You disarmed yourself.
Yeah.
Both of those doctrines, mind you, excuse me, had it built into them that they would develop over a time, right? That's what's called federal common law, and the common law always develops in certain respects, and by the same token, what exactly discriminates or does not discriminate against interstate commerce will hang on real-world conditions, which you don't know the minute you crank up the doctrine. It will have to have some give in it, and I think all of that is tolerable, provided you keep the doctrines close to the Constitution and remember where they came from.
And so these doctrines would be, in your argument, close to Article 1, Section 10, primarily. They would be derivable from restraints that are put on states interfering with trade in that particular part of the Constitution.
Well...
You would start there.
I might start there. I mean, that actually, the derivation of these doctrines becomes a very, very contested question, and you have to think very, very carefully about it, okay? So the Dormant Commerce Clause could come from an understanding that says the Commerce Clause itself, the actual Commerce Clause, as Justice Scalia always called it, that it It is exclusive, and so therefore the states can't mess with it. You can get it from the general, as I would prefer, the general principles of statehood that underlie the Constitution, which means that they're territorial, they're equal, and they're bound by a principle of non-aggression. The entire Constitution structurally reflects those features, and the Dormant Commerce Clause is the best approximation of that feature that you can come up with. And as for federal general common law, I think that you have to start with the structure of Article 3 and what it was supposed to be doing. And if there isn't federal general common law for those kinds of disputes, then the federal judiciary can no longer do what it's supposed to be doing. And that's pretty straightforward to mine. I mean, at least as a first approximation, that argument is pretty straightforward. It takes an awful lot of work to make it go. But that's the nature of the beast. And I refuse to propagate or adhere to constitutional understanding that says you're no longer even allowed to ask those questions.
Yeah, no, I mean, it's interesting, too. I mean, I just interviewed Ilan Werman on this show, who wrote an introduction to originalism. I mean, one of my questions to him was, in a way, originalism has become dominant, so much so that even progressives like Jack Balkin now call themselves progressive originalists. We have a libertarian originalism. We have original originalism or original public meaning originalism that came out of Bork and Mies, et cetera. So what does this all mean now? It seems to me you're not at odds with a spirit of originalism.
No.
I don't think. Yeah.
No, not at all. I'm just saying it's not enough.
Yeah. Okay.
We cranked this up in the 1980s, and good for us. But sooner or later, you ought to have a second thought.
Yeah.
And mind you, I mean, the disintegration of originalism to the point where, Jack Balkin calls himself an originalist, albeit barely, and where originalism on the conservative side now has come to embrace positions to the effect that, well, the 14th Amendment, gay marriage, that's what it meant all along. Let's put it this way, to keep originalism plausible, both theoretically and politically, because that's a position you now have to take to remain part of the conversation. At that point, maybe you have to reconsider the enterprise and figure out where exactly this has gone a little bit wrong.
Oh, that's interesting. That's interesting to think about. I mean, it seems also here, too, what's at play is self-government and republicanism, which is largely, it's sort of a muscular commitment to self-rule. In many respects, has gone by the board as a part of our politics. In a way, I think, unintentionally, perhaps originalism is a part of that. It seems to me. Maybe that's an unfair judgment on my part.
No, it may be. I mean, the reason why I'm hemming and hawing and equivocating now is that I'm not sure it's fair, but there's some, and it's certainly not fair to every originalist of every ilk and description. Yeah. But there is something to it in the sense that what motivated this was the search for a politically neutral methodology of understanding the Constitution. And one thing you learn from John Marshall, in addition to all other things, is that at the end of the day, there can be no such thing because the beast itself is connected to a particular vision of what Republican government actually means and how it's supposed to be operating. And people disagree about that, and in that sense, there can be no such thing as a politically neutral Constitution. And if you think there's a methodology or hermeneutics that allows you to have it, you're deluding yourself.
Yeah. No, it seems also, as I'm thinking, and maybe you're thinking about this too, it seems like the next big project for Michael Greve coming out of this is the John Marshall philosophy has applied to the administrative state. You applied it previously to federalism. How do you use this similar thinking to reach proactively, creatively to these problems that are now roiling us?
Yeah, look, I'm not John Marshall, and emphatically not. And
you know John Marshall better than he knew himself.
Yeah, no. Let's put it this way. I mean, that Grant style, as Grant Gilmore called it, of judicial reasoning has gone out of style. And after successive waves of formalism, realism, legal process, formalism again under a different name, originalism, you can't just go back to something that has that has seen so many convulsions over time. But what you can salvage, I think, is some of the underlying impulses and a way of going about or understanding the constitutional enterprise as a whole. And I think we've lost a little bit of that, and maybe it's possible to recapture it.
Well, Michael Greve, we all wait with bated breath for you to bring a firm constitutional philosophical foundation to that.
There you go. I'll get back to work.
Michael Greve, thank you so much for joining us on the challenges to constitutional government. We really appreciate your comments today. Thank you.
Richard, thanks a bunch.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.